Good afternoon, classmates. Good afternoon, Engineer Arnado. This is Raymar Macarayan, and I am one of the reporters of Chapter 2, which entitled Nature and Effect of Obligations. So, Chapter 2 covers 16 articles from Article 1163 until Article 1178. So, for my part, I will be discussing Article 1163 to Article 1170. For the remaining articles, it will be discussed by my co-reporter, Mr. Kyle Labajo. So let's start. There are many things that encompass obligations, such as an obligation to provide basic needs to children, deliver goods and services, perform agreements stated on the contract, and many others. So when these obligations are not fulfilled, the burden will be on the individual who made a promise. Avoiding these obligations have legal implications according to the provisions of Chapter 2 of the Civil Code of the Philippines. Now, let's have Article 1163. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. Diligence of a good father of the family stated that which is required by the nature of the obligation and corresponds with the circumstances of person, time, and place. So the phrase has been equated with ordinary care or that diligence which an average or a reasonably prudent person exercises over his own property. So the diligence of a good father referred to in the last paragraph of the aforecited statute means diligence in the selection and supervision of employees. Thus, when an employee, while performing his duties, causes damage to persons or property due to his own negligence, there arises the presumption that the employer is negligent, either in the selection of the employee or in the supervision over him after the selection. For the employer to avoid the solidary liability for a tort committed by his employee, an employer must rebut the presumption by presenting adequate and convincing proof that in the selection and supervision of his employee, he or she exercises the care and diligence of a good father of a family. So to sum up Article 1163, this refers to an obligation to give. It notes the standards of care which the debtor must exercise in the preservation of the object prior to delivery, as provided by law, as stipulated in the contract, and proper diligence of a good father of the family. Next article is 1164, stated that the creditor has a right to the fruits of the thing from the time the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. So this article is a logical application of the basic principle stated in Article 712, paragraph 2 of the Civil Code, that ownership and other real rights over property are acquired and transmitted by law, by donation, by testate and intestate succession, and in consequence of certain contracts by tradition. By law, the creditor is entitled to the fruits of the thing to be delivered from the time the obligation to make delivery of the thing arises. So let me give you an example of this. On November 1, 2011, Juan obligated himself to deliver to Pedro a specific parcel of land on November 30, 2011. If on November 1, 2011, Juan has not delivered to Pedro yet, Pedro acquires the personal right to demand the delivery of the land and the fruits thereof from November 1. However, Pedro acquires real right or ownership only from the time of actual delivery. From that example, it talks about personal right and real right. So, what are those rights? So personal right meaning to say the power of one person to demand of another as a definite passive subject the fulfillment of a prestation to give, to do, or not to do. So therefore, personal right is binding or enforceable only against a particular person. So next right is real right. Real right is the power belonging to a person over a specific thing without passive subject, individually determined, against whom such right may be personally exercised. So a real right is directed against the whole world. So to give you more differentiation about the two, let me say this. So the personal right of the creditor can be defeated by a third person in good faith who has innocently acquired the property prior to the scheduled delivery, regardless of whether or not such third person acquired the property after the right to delivery of the thing has accrued in favor of the creditor. And acquisition of real right means that such right can be enforceable against the whole world and will prejudice anybody claiming the same object of the prestation. So the real right only accrues when the thing or object of the prestation is delivered to the creditor. So next article is 1165. Stated, when what is to be delivered is a determinate thing, the creditor, in addition to the right granted him by Article 1170, may compel the debtor to make the delivery. If the thing is indeterminate or generic, he may ask that the obligation be complied with at the expense of the debtor. And if the obligor delays or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has effected the delivery. So, from this article 1165, it clearly stated about specific or determinate object or generic or indeterminate object. So now let's find out what are those specific or determinate object. It means that sufficiently described and can be identified. It can be identified by its individuality. Meaning to say, the creditor has the right to compel debtor with his prestation, with right to ask for damages in case of non-compliance. Next is generic or indeterminate. So from the word itself, generic means general. So not sufficiently described or identified only by its PT. So this one, the creditor may demand specific performance. Creditor may ask third party to comply with the prestation at the expense of the debtor plus damages. Next is Article 1166. Stated that the obligation to give a determinate thing includes that of delivering all its accessions and accessories, even though they may not have been mentioned. So, from this article, it discusses about accessions and accessories. So, what are those? So, accessories, those artificially added or attached for purposes of adornment or embellishment. So accessories are things joined to or included with the principal thing for the latter's embellishment, better use, or completion. Example of this is key of a house, frame of a picture, bracelet of a watch, machinery in a factory, and a bow of a violet. Next is accessions. Those artificially added or attached naturally or artificially for purposes of increasing its serviceability or utility. So accessions are the fruits of, or additions to, or improvements upon, or a thing or the principle. So example is house or trees on a land, rents of a building, air conditioner in a car, profits of dividends accruing from shares of stocks, and etc. Next article is 1167. If a person obliged to do something fails to do it, the same shall be executed at his cost. This same rule shall be observed if he does it in contravention of the tenor or of the obligation. Furthermore, it may be decreed that what has been poorly done be undone. So this article contemplates three situations. First is the debtor fails to perform an obligation to do. Number two is the debtor performs an obligation to do but contrary to the terms thereof. Or three, the debtor performs an obligation to do but in a poor manner. So, from this article, it refers specifically to an obligation to do. However, this does not apply to an obligation highly personal in nature. Here, the only remedy is to seek indemnification for damages in case the debtor fails to comply with his obligation. Next article is 1168. When the obligation consists in not doing, and the obligor does what has been forbidden him, it shall also be undone at his expense. So, in an obligation not to do, the duty of the obligor is to abstain from an act. Here, there is no specific performance. The very obligation is fulfilled in not doing what is forbidden. Hence, in this kind of obligation, the debtor cannot be guilty of delay. To give you more clear understanding about it, let me give you an example. So, S sold a land to B. It was stipulated that S would not construct a fence on a certain portion of his land adjoining that sold to B. Should C construct a fence in violation of the agreement, B can have the fence removed at the expense of S. So generally, Article 1168 does not apply if what is done cannot be physically or legally undone. Creditors' only recourse is to sue the debtor for damages. Next article is 1169. Those obliged to deliver or to do something incur in delay from the time the obligee judicially or extrajudicially demands from them the fulfillment of their obligation. However, the demand by the creditor shall not be necessary in order that delay may exist. When the obligation or the law expressly so declare, or when from the nature and the circumstances of the obligation it appears that the designation of the time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of the contract, or when demand would be useless, as when the obligor has rendered it beyond his power to perform. In reciprocal obligations, neither party incurs in delay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. From the moment one of the parties fulfills his obligation, delay by the other begins. So, from this article, it discusses delay. So, meaning of delay. The word delay, as used in the law, is not to be understood according to its meaning in common parlance. A distinction, therefore, should be made between ordinary delay and legal delay, or known as default or mora, in the performance of an obligation. So, from the meaning itself, delay talks about ordinary delay and legal delay. So, what is ordinary delay? Ordinary delay is merely the failure to perform an obligation on time. Otherwise, legal delay or default or mora is the failure to perform an obligation on time, which failure constitutes a breach of the obligation. So, that clearly states the meaning of ordinary delay and legal delay. So, there are kinds of delay. First kind of delay is mora solvendi. So it is a delay or default committed by the debtor to fulfill his obligation. So mora solvendi ex re is the obligation to give, and mora solvendi ex persona is the obligation to do. So this kind of delay is the delay on the part of the debtor to fulfill his obligation to give or to do by reason of a cause imputable to him. So this kind of delay has following effects. So first is the debtor is guilty of breach of the obligation. Second is he is liable for interest in case of obligations to pay money or damages in other obligations. In the absence of extrajudicial demand, the interest shall commence from the filing of the complaint. And lastly, he is liable even for a fortuitous event when the obligation is to deliver a determinate thing. However, if the debtor can prove that the loss would have resulted just the same even if he had not been in default, the court may equitably mitigate the damages. Another kind of delay is mora accipendi. It is a delay or default committed by the creditor to accept or acknowledge receipt of the object due. So this delay is a delay on the part of the creditor without justifiable reason to accept the performance of the obligation. It also has it also has following effects. First is the creditor is guilty of breach of obligation. Second is he is liable for damages suffered, if any, by the debtor. And number three, he bears the risk of loss of the thing due. And number four, where the obligation is to pay money, the debtor is not liable for interest from the time of the creditor's delay. And lastly, the debtor may release himself from the obligation by the consignation of the thing or sum due. Last kind of delay is compensatio mori. So it is a delay of the parties or obligors in reciprocal obligations. So compensatio mori or the delay of the obligors in reciprocal obligations, like in sale, is the delay of the obligor cancels the delay of the obligee and vice versa. So compensation mori, the delay of the obligor cancels out the effects of the delay of the obligee and vice versa. So the net result is that there is no actionable default on the part of both parties such that as if neither one is guilty of delay. So let me give you an example of this. S obliged himself to deliver to be a specific refrigerator on December 10. If S does not deliver the refrigerator on December 10, he is only in ordinary delay in the absence of any demand from B, although a period has been fixed for the fulfillment of the obligations. The law presumes that B is giving S an extension of time within which to deliver the refrigerator. Hence, there is no breach of the obligation and S is not liable for damages. If a demand is made upon S by B on December 15 and S fails to deliver the refrigerator, S is considered in default only from the date. If an action for specific performance is filed by B on December 20, the payment of damages for the default must commence on December 15, when he made the extrajudicial demand and not on December 20. In the absence of evidence as to such extrajudicial demand, the effects of default arise from the date of the judicial demand, that is, from the filing of that complaint. So, from this example, it means that the delay in the performance of the obligation must either be malicious or negligent. Hence, if the delay was only due to inadvertence without any malice or negligence, the obligor will not be held liable under Article 117p. Default generally begins from the moment the creditor demands the performance of the obligation. Without such demand, judicial or extrajudicial, the effects of default will not arise. If the delay of one party is followed by that of the other, the liability of the first infractor shall be equitably tempered or balanced by the courts. If it cannot be determined which of the parties is guilty of delay, the contract shall be deemed extinguished and each shall bear his own damages. Commencement of a suit is a sufficient demand. The obligor is liable for damages for the delay from the time of extrajudicial or judicial demand. So that's the meaning of the example. So basically, Article 1169 is applicable only when the obligation is to do something other than the payment of money. Last article is 117. Those who in the performance of their obligations are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof are liable for damages. So technically, Article 1170 pointed out negligence and fraud. So fraud may be distinguished from negligence as follows. So in fraud, there is deliberate intention to cause damage or injury, while in negligence, there is no such intention. Another one is waiver of the liability for future fraud is void. And while such waiver may, in a certain sense, be allowed in negligence, that's the difference. So next is fraud must be clearly proved, mere preponderance of evidence not being sufficient, while negligence is presumed from the breach of a contractual obligation. And lastly, liability for fraud cannot be mitigated by the courts, while liability for negligence may be reduced according to the circumstances. They are similar in that both are voluntary. That is, they are committed with volition, but in fraud, a party by his voluntary execution of a wrongful act or a willful omission knows and intends the effects which naturally and necessarily arise from such act or omission which deliberate intent is lacking in negligence. So Article 1170 gives the four grounds for liability which we entitle the injured party due to damages. So you can see it in Article 2197. For all kinds of obligations regardless of their source, mentioned in Article 1157, whether the obligations are real or personal. It also contemplates that the obligation was eventually performed, but the obligor is guilty of breach thereof. Here, the breach of the obligation is voluntary, but in Article 1174, it is involuntary. So, under Article 170, fraud or deceit or dulo, as used in Article 170, it is the deliberate or intentional evasion of the normal fulfillment of an obligation. You can see it in 8 Marinsa 72. So as a ground for damages, it implies some kind of malice or dishonesty and it cannot cover cases of mistake and errors of judgment made in good faith. It is synonymous to bad faith in that it involves a design to mislead or deceive another. Under Article 1170, the fraud is employed for the purpose of evading the normal fulfillment of an obligation, and its existence merely results in breach thereof, giving rise to a right by the innocent party to recover damages. So the civil code refers to civil fraud. Criminal fraud gives rise to criminal liability. Still under Article 1170, negligence or fault or culpa. It is any voluntary act or omission, there being no malice, which prevents the normal fulfillment of an obligation. Next is delay or mora. It has been ruled that the delay in the performance of the obligation under Article 1170 must be either malicious or negligent. So this has already been discussed under Article 1169, which determines the commencement of delay. Last part under Article 1170 is contravention of the terms of the obligation. This is the violation of the terms and conditions stipulated in the obligation. So the contravention must not be due to a fortuitous event or force majeure. If any of these four bases of liability coexist with a fortuitous event or aggravates the loss caused by a fortuitous event, the obligor cannot be excused from being liable on his obligation. I guess that's all for my part. Thank you for listening and good day.